dive into our panel discussion, how the new labor secretary will shape HR. But first, let's get into introductions. I'm excited to welcome our expert panelists today. We have Rachel Ulrich, partner at Ford Harrison, and Nick Kowalczyk, Vice President, Chief Risk Compliance and Privacy Officer at Kelly Services. Before we dive into our topic, we'd like to give our panelists a moment to briefly share their background. Rachel, would you like to go first?
Sure. Hi, everyone. Thanks for joining us today. My name is Rachel Ulrich. I'm a board-certified labor and employment attorney here in Texas. I'm based in Dallas at Ford Harrison's Dallas office. I practice all around the state and across the country. I'm an employment law litigator, so I represent employers in all areas of employment law, from counseling services, training, charges, lawsuits, appeals, you name it. You know, I'm pretty much got my hands in it.
Nick?
Great, thanks, and happy to be joining everyone. I'm Nick Kowalczyk. I'm Chief Risk Compliance and Privacy Officer for Kelly. So prior to running our risk management group, I was a labor and employment attorney as well at Kelly. And prior to being at Kelly, I was in a boutique labor and employment law firm here in Troy, Michigan. For those of you who don't know Kelly, we're a staffing and outsourcing company. We connect people in ways with work in ways that enrich their lives. And we connect those companies with people who drive innovation and growth. You can check us out at kellyservices.com if you haven't had an opportunity to work with us before. I do also want to give a quick shout out to our customer and partner, Cummins. They recommended us to participate. It's always great to have a customer who views not only as a service provider, but also as a good strategic partner to participate in these type of events. So happy to be here.
Absolutely. Thank you so much for sharing. And again, thank you to everyone who's joining us today as well. All right. Now, as we all know, the workplace is constantly evolving and HR professionals are on the front lines. Today, we're here to discuss critical policy shifts that will impact the HR industry in 2025 under a new labor secretary. This includes immigration regulations, workplace safety, and of course, the joint employer rule. And to kick us off, we're going to just go right into things. What are the most significant legal and regulatory changes that HR leaders should be aware of in 2025? Nick, would you like to go?
Sure, absolutely. So I think one of the, obviously new administration coming in and a change of responsibilities and priorities. That I think is probably an understanding where those potential changes are coming from and really setting your strategy around to adopt to those the next few years. As Bianca mentioned, I think immigration is obviously one that's in the forefront of a lot of companies' minds, obviously looking at that and understanding where your risk exposure are and how you can see what will eventually come from the administration and how you can respond to those. What I will say is there's obviously a lot of ambiguity right now. There's a lot of, during campaign season, there's a lot of statements made and a lot of politicking going on. So it's really trying to sort through those pieces and say, what do we think will actually come into policy versus what do we think was something that was put out there that might not actually have any ground legs? And I think we'll get into some of that discussion today. One of the pieces that I think is actually relatively interesting is looking at a little bit of the state and federal divergence here. When you see some of the state regulations really trying to make up for a change in administration, especially in some of the states that are more pro-employee, that's really a dynamic to keep an eye out for. So even if you don't see federal action, you may see something on the more local or state level that could cause you to have to react in that area too. So really being mindful of not only the federal level, but also the state level is one of the things I'm really emphasizing right now. Obviously, a shift in administration can bring those changes and responsibilities. So really keeping an ear to the ground too and seeing what we think might actually be coming out from anything.
I think that's a really good point, Nick, because I think one thing this Trump administration has made very clear that they want to shrink the size of the federal government. And so with that, we are seeing more and more states taking the laboring oar to, how do we legislate for these things when we're not getting that legislation from the federal government. We're seeing that in wage and hour. We're seeing that in independent contractor law, various things to try to, federal government isn't handling it, so the states are taking the helm on that. I think that's a great point.
Thank you both. Thank you both so much. And Rachel, you just mentioned independent contractor law. Of course, that's one of the key issues in the gig economy. What would you say are some of the key factors courts consider in determining employee versus independent contractor status?
Yeah, I think it's one of those things that, it's always been control. We've kind of expanded that a little bit over the years, and we're going to see some, changes, I think, in the Trump administration. But what we're looking at basically is, does the worker have an opportunity for profit and loss? Is it something that, can they negotiate their pricing with how much they're getting charged for a particular project? How much the worker is investing in their in what they're doing. Are they providing their own equipment, their own supplies? The nature, and of course, the degree of control. And is work an integral part of? Is the work that they're doing an integral part of the employer's business? If the worker is making widgets, and the company's job, the company's business is to make widgets, there's a decent argument that they're not an independent contractor because they're doing what employees should be doing. You're also looking at things like, and this is one of those topics, and I know Nick can speak to this very well with independent contractors, is where we're seeing the states really take a handle on the independent contractor piece. For the last 2 years, I've handled like 4 or 5 Texas Workforce Commission tax audits on independent contractors, on independent contractor classifications. And in my career, I'd never handled one. And in the last 2 years, I've handled 4 or 5. And it's because states are like, hey, this is a great source of revenue for us. So we're going to start looking at, whether these people are actually independent contractors. Texas puts forth a really good laundry list that I think applies no matter what state you're in. The 20-step factor test. You can find it on the TWC website. And it gives you a list of all different things, such as, are they providing their own equipment? Can they make their own hours? Are they required to have a uniform? That kind of stuff. It's all listed in that Texas report. And if you can match 20 of the 20, your worker should be considered an independent contractor. Well, I've had varying results on whether the TWC agrees with me. But I really do think if you pay attention, particularly to the states that you're operating in, what their independent contractor test is, you're usually going to be okay on the federal level, in my experience. So I think it's important to really pay attention to those factors and figure out if these workers are actually independent contractors. Another really important thing to look at is how long have these workers been working for you? I can't tell you how many times I've had a client say, well, he's an independent contractor. I'm like, well, how long has this independent contractor been here? Oh, 3 years. If your independent contractors really should be project-based and not working for you for extended periods of time, because employees could be working for you for extended periods of time, not independent contractors.
And I want to jump back to something that Rachel said, talking about the state level. I think it's a really good call here because we saw, the nominee for the Labor Secretary, Chavez DeRemer, she actually was a supporter of the PRO Act. And that was a more employee-friendly federal bill that would have really defined the definition of an employee much more broadly than it's typically been defined under state law. One of the few Republicans actually support that, and that actually had what's called the ABC test in there. It's kind of technical, legal in nature, but it's important to understand that some of those states do have that, right? So as Rachel mentioned there, that's something I think I don't think obviously you'd see the Trump administration pursue that. It's a more aggressive policy than typically they've taken on labor. But that being said, it's an important thing to understand that there was a little bit more of a pro-labor tinge that we saw on the campaign trail than historically we've seen from that side. And so really looking at that and then saying, okay, historically, what did the Trump administration do last term? They looked exactly at that, economic reality, right? The nature. So the factor Rachel mentioned, the nature and degree of the individual's control, and that opportunities for profit and loss was the main focus of their old rule. So I think really looking at that, looking at the state side of that, and understanding what your relationship is very important to understand what the structure of your work is there. That fundamentally, that 20-point test, and then there's various forms of it that come in various state laws and all those other areas. But that 20-point test is a great place to look at that and say, okay, how do I really understand my relationship with these individuals and what risk I have about whether or not they're misclassified as independent contractors or workers.
I love that. And you actually just led me to my next question I was going to ask, Nick, which was about those risks. What are the potential risk and liabilities associated with misclassifying workers?
Sure. So obviously there's a simple wage factor, right? If you're classifying someone as an independent contractor rather than an employee, you're probably paying them on a different structure than an hourly rate. So there's minimum wage requirements, there's overtime pay requirements. Those are the kind of monetary pieces of it. But as Rachel mentioned, there's also employment tax exposure. States love to get their employment tax here. So you really need to understand that not only can it just cause the basis side of the wage pieces, but it really goes further, right? You start looking at your employment law tax exposure, potentially immigration exposure if you're not I-9ing those people because they're independent contractors. There's job protected leave laws. There's job protected benefits in states. Unemployment contributions, workers comp premiums, and also, we've seen the decline in the retro benefit cases, better safeguards overall now, but obviously that's still something that's out in the back of people's minds when we talk about an independent contractor misclassification as well. So it can really have some serious consequences if you have individuals misclassified as independent contractors instead of employees. So doing that evaluation and understanding your risk for your population is extremely important.
Yeah, because you have to look at it too from the state and federal perspective, because you are likely not paying not only state taxes, you're not paying federal taxes as well. So you could very well get yourself in trouble with the IRS if a state finds that you have misclassified your workers.
Those are big things there. We don't want those to happen. Of course, you just mentioned a couple of things already that HR leaders and organizations to be aware of, so they do not, misclassify workers. But is there anything else that they should be keeping in mind to ensure compliance with the latest independent contractor laws, just to cover all bases?
So
I see you smiling. Oh, yeah,
no, I'll jump in and then I can kick to Rachel. And it's probably a good transition here. I would say one of the most important things is work with counsel on these type of issues. These are complex issues, right? We're talking about a bunch of legal tests here. They vary based on state jurisdiction or federal jurisdiction. So it's not something that's easy to decipher, and the landscape is shifting. So one of the most important things I would say is to work with your attorneys, right? Work with a law firm that you're comfortable with. Find a way to, analyze your current population, but also understand how you can build a repeatable process and then follow that process.
Yeah, I think that's very important, because if you discover through this process that your workers have been misclassified, it's also then you're going to have to work with counsel to figure out how to communicate that in such a way that you're not increasing your potential liability. So you're going to be dealing with an employee morale issue. How do you address that if you have to reclassify your workers?
Thank you both so much for sharing that. We're going to move on to our next subhead here. It's another key issue in the gig economy, and that's overtime regulations. What are the latest updates to overtime regulations, and who are they likely to impact?
Well, the new regulations are dead. Dead. Well, in December of 2024, Judge Sean Jordan of the Eastern District of Texas overturned the new regulations as to overtime, specifically the the increase in the salary threshold for who is and who is not an exempt employee. I don't think that had a super big impact because most employers had already either decided they were going to adjust their employees' pay or their how they categorize them appropriately before that decision had come out. I only saw one employer, I think it was Ohio State University, who tried to pull back their bumps that they gave to certain employees in order to meet the salary threshold, because most attorneys were advising, it's a PR nightmare and a morale nightmare for you to give an employee a raise and then take it back. No one ever wants that. So I think right now we're at that stage. Wage and hour law is, it's complicated. Most people are going to do something wrong. We very rarely find an employer that's 100% compliant with wage and hour law. Just because we have this law that was developed in 1923 and isn't adapted towards modern English or modern times, and how we do business nowadays and who works nowadays. And so, I would love nothing more than to see a new presidential administration revamp the FLSA and make it easier to understand for employers. But I don't see that happening anytime soon, to tell you the truth. So, yeah.
Yeah, I think it's spot on in terms of the really antiquity of some of the wage hour laws we're dealing with. Some of the practices they talk about just aren't adopted to the reality of modern work. Especially we talk about technology, inclusion work, remote work, all of those pieces. Those are pieces that the regulations have over time struggled to, I think, really to adapt to. Looking forward, with the increase being dead based on that, the court decision, and then obviously the Trump administration coming in, I don't think we really know that it will be a priority for them to really go back and look at the salary basis test, to look at that. I could, again, seeing that little bit of pro labor trend, it's potentially do something more mid ground, and bump that up slightly, maybe in a future year. I would not expect it to be a priority for them coming in right off the administration. But I could see them trying to put in a new rule over the next few years that maybe move that salary basis test up slightly. I think you'll see it be, again, probably more pro-employer than the previous proposals that we've seen from the Biden administration.
And overtime is one of those things that the states have kind of taken charge of. I think this year as of January 1st, there are now 22 states that have increased their minimum wage. And so employers really have to pay attention now to the wage and hour compliance of, the various states. Certain states now, such as New York, have different overtime rules or different wage rates for different types of industries. Like the fast food industry, there's specific things, wages that have to be paid. And so paying really close attention to what the states are doing is going to tell us a lot more, I think, than what the federal government's going to be doing in the next few years when it comes to wage and hour law.
Yeah, and if you go, so if you're in California, you probably are familiar with this as an employer, but you can even go to the local level. The Bay Area and LA area in particular have local laws around minimum wage too. So depending on where you're working can actually vary by your local jurisdiction there and what the minimum wage rules are. So I think that's a really good call out to say that especially in an area where we see a very divided government and not a lot of bipartisan legislation coming out of Washington. That's that trend that we've talked about those states increasing and really looking at what they're doing, and the local jurisdictions as well, of really saying we're going to specialize this to see what we want to do for our population. And so having your ear on the ground and more local and the state side of that, I think is really important.
Great tips. Thank you both for sharing that. And great call out too, Rachel, for you looking at what others, of course, states are doing, but what other industries are doing as well. What other practical strategies can HR leaders take to make sure that they're staying on the pulse of these things and not allowing anything to get ahead of them?
Yeah, I mean, I think it's first and foremost, pay attention to, organizations such as SHRM, your favorite law firm's website about, we put forth legal alerts regularly about increases or changes in the law, the latest and greatest of what's happening. I think really, keeping an eye on those trends and attending webinars such as this can really be helpful for for an HR person, just to make sure they're staying up to date about what's going on.
Absolutely. And of course, this prompts me to segue into unionization trends, another big topic here that we have, and of course that we're seeing. How can HR proactively address union union organizing efforts? And you both are smiling, and that's usually my go-to to call on someone. Nick, would you like to go?
Yeah, I think understanding the nature and tone of your workforce is super important right now. So if you do look at surveys, there is a recent Gallup survey, and there's more support for unions, I think, than there ever has been in quite a long period of time. You go back to 2001, it was 60%. 2009, it dropped to 48%. It's at 70% right now in that survey. Which is pretty significant. And I think you saw, again, talking about what we saw on the campaign trail a little bit, I think you saw a little bit more pro-labor tone, especially coming from the Trump administration than some typically expect from that administration. So it's really important to understand where your population is, what your risks are, what you see in your workforce, and understand the tone, I think, overall of the national trend that we've seen of a more pro-union workforce. Union petitions have doubled since fiscal year 2021, according to the National Labor Relations Board. It's up 27% over last year, so it's quite significant that we've started to see these increases. So I think it's something that historically the trend had been downward, and we're starting to see that reverse a little bit, right? So really understanding the population of what you're seeing, and then understanding really what you have going on in your workforce, what your workforce concerns are. What you see, what you hear from your manager, what your pulse of that entire population, that really helps you understand what the potential risks are and what you need to do. Obviously, this area is rife for issues as well. So it's really important to engage with someone who has that strategy and background around labor organizing, around really working through those type of campaigns as well. There's been some shifts in the law recently here as well, especially as it relates to captive audience meetings for employers too. So something important to keep in mind there.
Yeah, I mean, I think I absolutely agree with you, Nick. It's going to be interesting to see what happens with the Trump administration this time around and organized labor, because, I mean, first and foremost, his nominee for the DOL head is very pro-labor, which isn't something you generally expect from a Republican, and then you see that his constituents tended to skew more blue collar, and they're paying more attention to the Republican Party is paying more attention to labor unions now, which is very interesting considering we just had what most people considered the most pro-labor presidents that we have had, Biden. And to see how we're going to adjust with President Trump again is going to be very interesting. But I think one thing every employer, particularly those employers, that are, have a more blue collar environment, is manager training. That's such an important thing to implement. We spend so much time training our managers on how to look out for sexual harassment or discrimination in the workplace. But when you're dealing with an employer group who has the potential to organize, having manager training on how to keep an eye out for possible union activity, how to respond to possible union activity, and make sure you're complying with tips and faux. Those are all very labor terms: no threats, intimidations, promises, or surveillance. It's so important to do that. Just spend some time to open up your managers' eyes to what they need to be looked for, particularly if you've got a management team that has largely come up from the ranks. We often have if you've got a management team that has come up from the ranks, they're very used to being the employee and not necessarily the manager, and they may miss some things or agree to some things that you don't want them to do as an employer when it comes to a unionization campaign. So I think going to a labor and employment firm or one of those labor groups that train managers on how to look for and how to handle possible union organizing is really important. Even if you don't think anything's going on, it also helps your managers really know to keep an eye out for, just in case.
And jumping back to a theme I think you mentioned before, Rachel, is just the nature of the laws. Obviously, these laws are also written from a long time ago, but organizing has changed, right, over the course of years. Especially now, you're seeing more organizing activity occur in social media, those other platforms. So even learning about the new ways that there are organizing activities occurring is a super important piece. You think of the traditional people in the parking lot handing out leaflets, authorization cards. Yeah, that still happens. But I think understanding the new ways that the union really does organizing activity, understanding what to be on the lookout for, especially on the electronic front, is a really important piece. I've been involved in some campaigns where we were a side party, but importantly, learned a lot from what we see from the union activity in terms of how they engage in a lot of that activity.
Yeah, I think it's not necessarily gone are the days of, the union meetings at the local pizzeria. But a lot of it's happening through Facebook groups and, social media campaigns. And
Yep.
So it's have an idea of what to look out for.
Absolutely. And how can HR leaders foster positive employee relations to minimize the risk of unionization? Excuse me. Nick, you're nodding.
I think so. I said at the start, understanding the trend of your population is incredibly important. There's some drawbacks that come with surveying your population. Obviously, you may get information that you now have to act on, right? When you talk about employee engagement surveys and those type of activities, but they do give you a good sense of where you may be seeing issues and maybe issues that you might have blind spots to, or your management team might have blind spots to. So really understanding what the concerns are and figuring out if you have a way to address those within the population. At the same time, I think it's important to understand that you may not be able to remedy everything that come from those either, right? Inflation, as we saw the past few years, has gone up significantly. You may not be able to raise wages at a rate that's going to make your employee population happy and still be profitable. So, understanding that, but also understanding and building in that risk factor to be able to say, these are where we can go to address those concerns, but also at the same time being realistic about where you need to be from a business perspective.
Yeah, I think a lot of it comes down to listening to your employees, but not only just listening, taking action where appropriate. even if you can't help a particular employee, like with, raises at a particular time, just being able to explain to an employee, look, we're not going to be able to give you a raise this year because of this, that, or the other, but, let me look to see if I can get you some more overtime, or, maybe we can, get you an extra day off. Something like that may be, even if you can't give them the answer that they want to hear, always give an employee an answer. Because I think nothing angers an employee more than not getting a response. Because then they just feel unheard. And if an employee feels unheard, they're more likely to go to a third party to get their answers.
Great advice. Great tips there. Let's talk about workplace safety. How can HR develop and implement effective workplace safety programs? Oh, no smiles there.
Like, oh, OSHA. OSHA's going to be interesting. OSHA's another thing that's going to be interesting this year, because it is one of the departments that they're really looking at shrinking. And there's not going to be as many investigators to look at, incidents and accidents. I expect a slight rolling back of, the electronic disclosure of reporting that the Biden administration implemented. But I think a lot of it I think it's another one of those situations where you really have to look at your workforce and see what are the needs of your particular workforce. During the Biden administration, they put forth the heat protection program, OSHA did. It was designed to make sure, employees don't get dehydrated, when they're working out in the, the hot sun. And so, if you've got employees that are working out in, hot factories or, outside, look at those kinds of guidance from OSHA to see, what is being recommended. And I think too, with health and safety, this is another area where the states have kind of really taken over, and you have to look at the state OSHA requirements as well as the federal OSHA requirements to make sure that you're in compliance. But I think a lot of what you need to do is look at your particular workforce and what the needs are of your particular workforce when it comes to employee health and safety. We got pretty good at it during the pandemic. We had to kind of figure out a lot, as we went along, because, we hadn't really lived through this before. So now when it comes to employee health and safety, when it comes to airborne diseases and things like that, I think we're pretty good at figuring out, okay, employees really shouldn't be at work if they're contagious. How to address that. But we have to now look at, okay, what other health and safety things do we have to worry about? Look in California, what's going on right now. We have the wildfires. How is that impacting your employee population? Do you have employees who have, respiratory issues, asthma? How are they being impacted, and what are you doing as an employer to, aid those employees to make sure they're breathing, clean air to the extent you can? And so it's really about looking at your workplace and figuring out how to make it safer.
And Rich, I'll add a great way to do this, if you don't have any just real background of doing this, or if you're a smaller company or don't really have a safety department that you can pull from, go to OSHA.gov, and they have if you go to topics and employers, they have a compliance assistant quick start guide you can pull up. They also through that will have a small business checklist and a small business handbook that you can look at and pull up for really practical tips to do an assessment of your work site. Right. So that's to Rachel's point about really understanding what your employee population is. That's going to walk you through a step-by-step piece of what OSHA's expecting you to do, and really understand your potential risks within that workplace and your population. And that might mean, hey, there's sometimes unique environments you're sitting in, if it's confined spaces, loud noises, you're working with respirators. There's all those different requirements that are in there, but they do have great guides that if you're really looking for a place to just start, right? Really practical tip, go to the website and really try to go through some of those compliance pieces and guidebooks that will really help you understand where it is, because you may need to eventually engage someone who has more subject matter expertise in that area, but it gives you a great starting place of really understanding your risk-free population.
And I also spend some time every year looking at your workers' comp claims. What types of workers' comp claims have you had over the past year? Do you see any patterns? Do you see oh, wait, we've had 4 slip and falls in this same spot? Maybe that's something we need to look into. Maybe it's not it's not an employee issue. It could be there's, wet cement there for some reason. So if you take a look at the trends you're seeing in your workers' comp claims, it might provide you some guidance on, what health and safety issues you need to take care of next.
Great insights, everyone. And then, of course, we have the joint employer rule. And how can HR mitigate the risk associated with joint employer liability?
Rachel, I'll let you go first on this one. I'm obviously coming from a staffing company. I have our view on this. I'll come in, but I think it's important that you go first on this one. So.
Yeah, no, I think joint employer is going to be interesting. I think you really just got to make sure you're separate as much as you can. If you're using the same handbook, at least change the cover to have your company's logo on it instead of the company that, could be your joint employer. You've got to look at things to make sure how separate you actually are. And really pay attention to those little details, because if everything's going centrally to one place, you're probably got a joint employer situation.
Yeah, and I think that's spot on. And I think it's really important to understand that, from our perspective, obviously as a staffing company, right, we understand this, we live this day in and day out. But it's important to understand that you need to structure your relationship with that third party appropriately. Understand where your risks are, understand how you've divided responsibilities, right? Use a good partner, right? If someone comes out of the woodwork that doesn't have any business experience with, they might not be there at the time that there is a lawsuit down the line, right? And you don't want to be left on the hook for all of that if they're doing something wrong either. So you got to use someone you trust. This rule changes back and forth, right? Whether it's NLRB or FLSA, it's flipped in administrations. Ultimately, the liability is the liability that anyone has when employing someone. It's allocating the risk across those parties, right? So it's structurally set up your relationship with that third service provider, that third party, in such a way that you're comfortable with, right? That's going to come down to negotiating that agreement. Good example of this, we just talked about safety, right? So as a host employer, right, if you have third-party employees on site, you still have a responsibility to those employees, even if you're not the employer of them, right? You should be working jointly with that third party to understand and allocate those responsibilities. So it's really important to have a good relationship, right? View them as a partner and really build that relationship up with those third parties to really understand that. If I had to project of where I think the rule is going to go, I think you'll probably see some new rule trying to capture more flexibility in those relationships. That's what we saw in the previous administration. It's just gone back and forth as we've changed administrations. But I think you will eventually see something trying to boost for more flexibility and understanding of the nature of a modern economy with gig workers, with temporary workers, long-term, outsourced workers, all of those pieces. I think that's where you probably will start seeing some of the administration look, but I don't know it's going to be the highest priority for them either.
That's awesome. And Nick, you just gave a lot of great information about, of course, working relationships with those third-party employers. So you just took the thunder right from underneath me. I want to say that. But are there any other best practices for managing relationships with third-party employers that the audience can take away? Anything else like that? Or Rachel, you too. If you give me all yours.
I think I think you need to, be familiar with your contract. Make sure that liability, or indemnification provisions are clear. Who's responsible for what? Make sure, you understand, that. And Nick, anything else?
Yeah, I think that's spot on. Look, I think sometimes it's important to understand. So again, coming from our background here and the way we view this, it's not different than how any other, our customer is going to view it, right? We're each trying to understand what our partnership and relationship is, but that's really important. And I say that, as a person who might be across the table negotiating something down the line as a service provider, but having that understanding, you can allocate those responsibilities differently and you can build your relationships differently, but knowing what you're doing, going into that with the knowledge, and then actually doing that. Having one thing on paper, but then doing something completely different also doesn't help, right? So if you start taking on as a company using a third-party provider, you start doing a bunch of stuff that you've told them they're supposed to be doing, that can be problematic on a day-to-day basis too. So it's building that relationship in the structure that you want it. As Rachel mentioned, the indemnification, the responsibility section of those agreements, but then also actually performing your relationship that way. Don't start taking on a bunch of stuff that you've told, that third party they're supposed to be doing either.
I thought you were about to say something else, Rachel. Thank you so much. Thank you. Great tips there. Great tips there. Okay, so now it's time to move on into our Q&A session. So of course, to our audience, if you have any questions for our speakers, please go ahead and put those into the Q&A box. And we actually do have some. So someone is asking, there is a lot of confusion over shared employees under California law. Do you see the federal government coming up with a superseding law?
So we just talked about we talked about the joint employer piece a little bit before, and I think what I would say is, yes, I think there probably will eventually be some change in the federal standards, but it's important to understand that based on the domain of the law, there may be a different joint employer standard. And so sometimes the states are still going to have rules that trump that, right? And so regardless of what we may see in the federal level, you still need to be aware of what's happening at the state level in terms of how they interpret those laws. And you also need to understand the dynamic of what particular domain of law it's in. The joint employer standard for tax is technically different than joint employer standard for workers' comp, which is technically different than wage and hour, which is technically different than labor, right? And so there's all these different tests that they slightly use. I think expecting the federal government to come in and solve all of that with federal legislation is highly unlikely, right? So you're going to see more domain-based stuff if you see something federally, and then you also need to keep monitoring the stuff, these states. I don't think we're going to get some sort of silver bullet to solve that complex dynamic between that. I just think it's more likely we continue on this path than anything else.
Absolutely, absolutely. And now that we've had this webinar, what are your final thoughts as we wrap this up? How can HR professionals prepare for this upcoming administration? Rachel?
I think a lot of it is just, it was interesting when I was thinking about everything that we were talking about just now. It really isn't any different than what we've been doing every 4 years. It really is about, doing the things that you're always doing and just keeping an ear out for something new. I think most employers try really hard to make sure that they're in compliance and
we might have just lost Rachel there. I can jump in and give my thoughts. I think it was actually probably we're going to say something very similar. Keep your ear to the ground. That's really important to me. We've heard a lot, obviously, coming through an election cycle, and it's trying to sort through what we view as could potentially happen versus what we actually think is going to happen. A great layout of this, right, is we've seen in the immigration debate right now. So we had a lot of talk about the H-1B visas being rolled back, and then we saw, some of the comments coming from the technology side saying, no, we actually use those H-1Bs a lot, right? So there's even internally some struggles about where they're going to see potential shifts in what we could see from the administration. So, if I had to speculate there, I think, there might be some changes in temporary protected status, right, for immigration status, but understanding, hey, we have to be on the lookout for resources that are going to help us out to understand what's going on. We have to be monitoring the situation, ready to react, right, be ready to pivot. But to Rachel's, intro point, this is what we see when we have a change in administration. This is what we see when you have a changeover in Congress. You've done this before. I think have confidence in your processes that you've built in place to monitor those pieces. Have confidence that you've been through this before. This isn't going to be earth-shattering, right? It's just be ready to pivot when you need to change those pieces. Be aware of your potential risk exposure and think about where you have opportunities to do some pre-work, right? Do some research, do some prep if you want to understand your potential exposure so you're ready when the time comes, if a rule is passed or a ruling does come down, to really be prepared to respond to it, right? Have some of that prep work done is a really important piece, but don't drive yourself crazy trying to predict what's going to happen either. I think that's really important message. Keep your ear to the ground, listen in, and then be prepared and engage your subject matter experts when the time comes, right? I don't sit in a counsel role for my company, but I go talk to my attorneys about stuff I need to talk to them about. Go talk to your outside counsel. It's going to be really important to make sure that you're doing those pieces right and setting your structure up appropriately when you need to do that.
Sorry about that. I dropped off. I'm back now.
Okay, glad to have you back. Would you like to finish if you remember what you were saying, or it's okay?
I think Nick just finished up what I was going to say. It really is about knowing your business, knowing your employees concerns, and figure out what your potential liability is. As to these issues, are there concerns that you have now? You're probably going to have those concerns in a year. So you might as well get prepared for them.
Absolutely. And we actually have a couple more Q&A questions here. Someone has asked, please briefly explain captive audience expectations. And I know you mentioned that earlier, Nick.
Yeah, so previously under the National Labor Relations Act, you could hold what are called captive audience meetings. Essentially, it's an employer positioning their point of view in terms of unionization activities, right? And you typically use this to communicate the employer's message about what your view is on, why you're providing good benefits, why you really want to work directly with employees as opposed to working through a third party. So that was been a long-standing campaign tool that employers have used. There was a recent case under the National Labor Relations Board called Amazon Services that basically said you can't do that in a mandatory meeting with threat of discipline, right? So, now you need to be more clear about talking about the subject of the meeting. If attendance is voluntary, there's no adverse consequences, that you're not keeping attendance records, those type of things like that. It's, again, probably something good to go talk to your labor and employment law counsel about. But it's just important to keep in mind if you're having a campaign activity, the law there has recently shifted on the captive audience piece. Could shift back, right, under a new administration. That's what we've just been saying the whole time, is it could easily flip back. But for right now, that's where that case sits, which is a pretty decent change in terms of employer messaging over what we've seen the past few decades, at least.
And I don't think we're anticipating a whole lot of changes when it comes to NLRB law in the next 2 years, because I think the next Republican appointee is going to be 2 years from now. So I think we're at that midpoint where I think we're still going to have a lot of Biden administration kind of rulings that are going to come out initially, and then we'll see a change probably midterm.
Great insights. And our final Q&A question here, since the NRLB oversees most of the union activity, is there really any significant concern about the new Labor Secretary's PRO Act and labor union previous support?
I think that's my simplest way to put it, right? I don't think you're going to see this administration back something like the PRO Act. I think the important thing to take away from Chavez de Remer's, labor union support is just you may see a little bit more like pro-employee type of sentiment come out on some of these key issues where there may be a little bit more of a pivot towards labor, not significant in my view. But I think you could see some of these pieces we've talked about, like making a moderate step on the FLSA salary basis test or a few other pieces like that. I don't think we're going to see the PRO Act reintroduced or really reintroduced and be successful anywhere. It's just a note to call out that it was with Chavez de Remer's nomination a little bit of a shift historically from what we've seen from previous administrations in terms of the labor view. So it gives some context to what we're talking about there when we talk about that administration. But I don't think the PRO Act is going to be anything really to talk about going forward.
Yeah, I agree. I mean, I think it's an interesting pick. But ultimately, I don't think it's going to represent any kind of shift in the party of their view on labor rights. I just don't see that. We may have a lot more communication about labor rights. The politicking part of it may, talk a little bit more about it than what we see, typically with the Republican administration. But I don't think the law is going to change that much.
Absolutely. Well, unfortunately, that's all the time that we have. Thank you so much to our expert panelists, Rachel and Nick, for being here with us today. And thanks, of course, to you and the audience. We really appreciate your participation. As I mentioned earlier in my introductions, this session has been recorded, and you'll all receive a link to today's recording through email in about 24 hours. Our next webinar in our series, Why Isn't This Working?, will be the Middle Manager Squeeze, retaining and re-energizing your frontline leaders on March 24th. You don't want to miss it. Sign up on HR Daily Advisor's event page on our website. And one more time, I would like to thank you all for attending our sessions today. Please have a great day. Thank you all.
Thank you.
Thank you.